All right. Hello, everyone, and thank you so much for joining us today. We are, thank you for joining episode 2 of The Road to Wellbeing. Our program today is on wellness program compliance. We'll be speaking about ensuring legality and success. And I'm happy to introduce our guest today, Barbara Zabawa, who is the Associate Professor of Law at the University of Missouri, Kansas City. So, a little more about Barbara. She's the owner and attorney of the legal firm at the Center for Health and Wellness Law. She's a passionate advocate for the health and wellness industry, and her firm offers legal expertise to help businesses in this field navigate the complex legal landscape. The center caters to a wide range of clients, including health and wellness product vendors, employers offering wellness programs, and even insurers and brokers. Their services focus on ensuring compliance with state and federal regulations surrounding health and wellness services. Barbara's dedication to the field is evident. She's not only a lawyer, but also an author of a book on workplace wellness programs and has created the certification program for health and wellness professionals. So, welcome, Barbara. Thank you so much for joining us today.
Oh, thanks for having me. It's exciting.
Of course, of course. So now, just to jump into what we'll be talking about today. Today, we'll be discussing a few different key legal considerations. We'll demystify HIPAA, ADA, and GINA, and other relevant regulations. We'll go a little bit into understanding legal requirements for data privacy and security. We'll talk about how to avoid some common legal pitfalls associated with incentives and participation. And we'll also discuss mitigating risks to ensure program fairness a bit. And I'll leave some time at the end for you all to ask any questions you may have as well. So, Barbara, are you ready to jump into our first question?
Absolutely. Let's go.
Awesome sauce. So, question number 1, can you please elaborate on the most common legal concerns one might have regarding creating and maintaining a wellness program?
Oh, yeah, that's a good one. So I'm going to just make sure we're all on the same page when we say wellness program. I'm going to assume we're talking about workplace wellness programs.
Mm-hmm.
And so having a wellness program in the workplace, there are some laws that you have to be knowledgeable about. One is the Affordable Care Act, and one is the Americans with Disabilities Act. There are some others, but those are the two big ones. And so when you are designing a wellness program, the first thing you have to know is your wellness program part of a group health plan? Is this workplace wellness program tied to the major medical plan that an employer might offer? And one way to discern that is, are you offering incentives? So if your incentives are tied to, say, premium, so how much you're going to pay in premium depending on your participation level in the wellness program, then there's a good chance that your wellness program is a group health plan. And that means you have to comply with the ACA, the Affordable Care Act, that is. And I don't know if you have follow-up questions about what that looks like, but if it's not a group health plan wellness program, meaning that maybe you offer it to all of your employees, and it doesn't matter if you're enrolled in the major medical plan, your incentives aren't tied to your premiums. Maybe it's just you're handing out gift cards or something like that. If you're using incentives, then you still, if you're collecting health information from employees, usually through biometric screens or through health risk assessments, then you're going to be subject to the Americans with Disabilities Act. So getting back to the original question, the most common legal concerns derive from whether you offer incentives for your wellness program.
Awesome. So could you share a little bit more about some of those legalities associated with the Affordable Care Act, since you brought it up in this question?
Yeah, so it depends on how you've structured your wellness program as to what you need to do to comply with the Affordable Care Act. If you've structured your wellness program as just participating. You want the employees to participate. You want them to take the HRA or the biometric screen. You want them to attend a lunch and learn or a health fair event, or you want them to join a gym, but you don't care if they go to the gym. You just want them to be a member of the gym. Those are all considered participatory wellness programs, and under the Affordable Care Act, the only thing you really need to do to comply is make sure everybody in a similarly situated group, so if all full-time employees or all employees who work at this facility or this geographic location, they're all offered that same incentive or type of wellness program, then that's it. You just need to make sure everybody's treated the same in those groups. But if you are having a wellness program that requires employees to do more with their bodies, like you need to move to earn the incentive, you need to eat certain things to earn the incentive, you need to stop smoking or not use tobacco to earn the incentive, or you need your measures, your metrics need to come within a certain range, your BMI, your glucose, your whatever it might be. Then those types of wellness programs under the Affordable Care Act are called health contingent wellness programs, and they need to be a bit more, they need to follow a few more rules in order for you to be able to charge people different premiums, for example, depending on how they do with the wellness program. And so it's called a 5-factor test. And the biggest one is that you have to give people a chance to earn that lower discount, that lower premium, or other reward by doing something else other than the original criteria to earn their reward. It's called a reasonable alternative standard. That's the biggie. You also have to give them notice that they can do that. But yeah.
Awesome. So just thinking of an example of like a health contingency workplace wellness program, that would be one. So for example, as I was working in employee wellness for a hospital system, our hospital staff had to complete like 4 coaching sessions, or they had to complete like a few challenges, or they had to complete a few different programs to earn rewards for a lower insurance premium. Would that be considered a health contingency plan?
Some of those, like attending coaching sessions probably is more participatory, because you don't have to like actually invoke some sort of health condition to attend a coaching program. That's like attending lunch and learns. Those are participatory. You just have to show up. Just showing up is not a health contingent wellness program. But if you're actually having to perform some physical activity or engage in a diet program, something that not everybody's going to be able to do because maybe they have an underlying condition that prohibits them from doing that. Maybe they're pregnant. Maybe they have a heart condition, and their doctors advise them you shouldn't be doing this kind of exercise, or maybe they're in a wheelchair. I mean, they that kind of stuff where not everybody's going to be able to participate because they might have some physical or other kinds of issues that prevent them from participating. Those would be what I would call health contingent.
Awesome. Thank you for clarifying that. So now I'm going to move on to our next question. All right, so our next question is, can you explain the different ways HIPAA applies to various health and wellness programs offered by employers or organizations?
Yeah, well, first we have to clarify what we mean by HIPAA. So HIPAA is the Health Insurance Portability and Accountability Act. And when it comes to workplace wellness programs, there's two ways HIPAA can apply. HIPAA can apply, like I was talking about with the Affordable Care Act, with the wellness incentive rules, because those incentive rules originally appeared in HIPAA and then they were modified in the Affordable Care Act. So sometimes when people talk about HIPAA, they mean the incentive rules, but other times they mean the privacy and security rules, which also can apply to workplace wellness programs that are, again, part of a group health plan. So I'm not sure which one this question is in reference to, whether it was the privacy and security rules or the incentive rules, because I already talked about the incentive rules.
Yep. So this is about the privacy and security rules.
Okay. All right. So privacy and security rules would apply if there's a covered entity involved. So that's one thing that, and when you're working with wellness instead of in traditional healthcare, where HIPAA applicability is never really in question. In the wellness world, it can be in question because you're dealing with health information, but just because you're dealing with health information does not mean that HIPAA applies. And that's a misconception that I think a lot of people have when it comes to the privacy and security rules of HIPAA. Is they think that, oh, well, if I'm disclosing health information in any context, the HIPAA privacy and security rules apply, and that is just simply not true. HIPAA privacy and security rules apply when there is a covered entity involved. And a covered entity, there's three types. There's clearinghouses, which I think no one is going to say doesn't exist in wellness. Those are like claims processors for health insurance claims. We're not dealing with that in wellness. But the other two are healthcare providers who conduct standard transactions. So that's a key. That's a key differentiator. They have to conduct standard transactions. They can't just be any healthcare provider. They actually have to engage in what HIPAA considers standard transactions, like filing in electronic insurance claims or encounter information. The Office of Civil Rights has identified what constitutes standard transactions. So if you are a healthcare provider who just has paper-based practice, cash-based practice, you're not really dealing with any sort of electronic communications, like claims filing with insurance. You're not subject to HIPAA, even though you're providing healthcare. But the big one for workplace wellness, the third type of covered entity that gets you into the HIPAA privacy and security world, is group health plan covered entity. So again, if your wellness program is part of a group health plan, you're tying incentives to premium, that's a good indicator that you are a group health plan, then yes, you're subject to HIPAA privacy and security rules. But there are plenty of workplace wellness programs where there is no group health plan involved. They're just maybe having like a health fair or some lunch and learns, or all the employees can participate in this walking challenge or this, healthy eating challenge. If that's the extent of your wellness program and anybody can join, and again, there's the rewards might be gift cards or PTO or something other than related to your health plan, major medical plan, then you probably not a group health plan, and HIPAA privacy and security rules wouldn't apply.
Awesome. Thank you so much for answering that question, Barbara. And I know you started mentioning a few different strategies. So are there any other practical strategies that employers may be able to apply to ensure the privacy of their employees when it comes to HIPAA regulations when working with group health plans?
Well, if you're subject to HIPAA privacy and security rules, then you better be complying, and that's a very robust compliance plan that you have to have. You have to have privacy and security policies and procedures. And following those policies and procedures is what's going to keep you in compliance. So not just, creating them and then putting them on a shelf, but actually, implementing those policies and procedures, adhering to them, getting frequent training on them. It's a whole world. HIPAA compliance is like something that you do constantly, and you're monitoring constantly. You have people on staff who are your security and privacy officers, and your vendors, your IT people are, up to, up to date on the latest HIPAA security requirements, whatever it is that the Office of Civil Rights and the NIST organizations are, recommending for encryption and, firewalls and all that stuff. I mean, that's a constant.
Yeah.
It's not a one and done thing. It's you're constantly top of mind in when it comes to HIPAA compliance.
Awesome. Thank you for filling us in on that. I'll move on to our next question now. So our next question, how can organizations design wellness programs to be accessible and inclusive for participants with disabilities? I think you touched on this a little bit in question 1.
This is a great question. I didn't even know who are these questions coming from, people who are in attendance, or is this kind of just?
Oh no, these are just pre-generated questions, but we have opened it up for attendees to also ask questions as well.
Oh, this is a great question, though. It's very timely. I've been writing a lot on wellness for my law professor job that I have, and one of the articles that's coming out, I think, in the next month or two in the Journal of Law and Health, is on countering bias in the wellness industry, particularly racial and disability bias with workplace wellness programs. And one of the things, the Americans with Disabilities Act already requires workplaces, employers who are subject to the ADA, which are employers with 15 or more employees, to already provide reasonable accommodations for employees for any terms and benefits that are offered through employment. And workplace wellness programs are definitely a term and benefit of employment. And so if a person with a disability, whether it's mental or physical, perceived or real, needs to be reasonably accommodated so they can participate. So if you have employees who are not ambulatory, and your wellness program consists of a walking challenge, then you need to think about, well, what if we have employees who can't walk? Then what? I mean, what are we going to do? Because we're offering like a prize to whoever walks the most steps, in a certain time period. Well, are you considering those employees who can't walk? What are you doing? How are you reasonably accommodating those individuals? But it goes deeper. I mean, as I mentioned in my countering bias in the wellness industry article, I mean, bias is more than just disability. It's racial. I go into how the use of body mass index as a wellness measure is racially biased, and disproportionately impacts African American women in particular. And so if you're structuring wellness programs that are rewarding people within a certain BMI, and about 5% of workplace wellness programs, according to the Kaiser Family Foundation survey, the latest survey, about 5% of workplace wellness programs do condition, or maybe it was 7%, condition rewards on meeting a certain BMI. You're using a racially biased measure, and you could be just adversely impacting and therefore discriminating against particularly individuals from African American and Hispanic origin. So wellness needs to do a much better job of inclusiveness and being aware and cognizant of inclusiveness, not just with disability, but with all other kinds of um, uh, characteristics of individuals.
Mhm.
I can talk way more on that. I have a lot more to say on this topic, but I don't have time.
We may need to have another conversation just on that, because I cannot wait to read that article personally. I think, as you mentioned, that is an area of wellness that I have noticed that a lot of things can be a little biased, and a little more ableist at times, because we're only thinking in the concept of like what the general kind of like corporate America mindset, which isn't
Mhm.
as inclusive as of a number of different people from racial backgrounds, and even thinking of the social determinants of health. Certain
Uh-huh.
people might not have access to go to a doctor. So if there
Correct.
is like a penalty against not being able to visit their doctor, but they don't have a method of transportation, how do you manage that too?
Yep. And that article talks about the social determinants of well-being, something that
Mm-hmm.
I want to see more discussion and addressing of by the wellness industry, not just workplace wellness, but wellness in general. Wellness is premised on personal responsibility. And that's what I'm writing about in my current article that I just started. I have several articles in the hopper, but the one I'm just writing now is defining what wellness law is. And how I'm defining it is in contrast to healthcare or bioethics or public health, where there's a top-down, more of a someone else knows best mentality. In wellness, what really differentiates it in my mind is that it's premised on the consumer, the individual knows best what's best for them and a personal responsibility. And that of course has um, positives and negatives. And one of the negatives of that is that when you're too focused on individual responsibility, you miss the environment in which that person exists.
Yeah,
And um, and
yeah.
and so we in the wellness industry need to do a better job of acknowledging that we can throw, healthy eating ideas at people all day long or exercise ideas all day long. But if an individual is not in an environment, either in their home or in their neighborhood or in their community, that is conducive to adopting healthy behaviors, and it because of their housing situation, their physical safety, maybe their domestic violence, discrimination at work or elsewhere, they're not going to be able to adopt those healthy behaviors. And then if you're tying incentives to that in the workplace, again, you are adversely impacting um, employees who are at a disadvantage. Usually they're historically marginalized people to begin with. So we really need to open our eyes to the broader picture and look at wellness as, even though it's premised on personal responsibility, we can't shut our eyes to the fact that people live in environments that either are supportive of healthier behaviors or not.
Mhm. I love that. That's why I love the approach of like the 8 dimensions of well-being. When we're looking at the individual, is looking at all those different aspects,
Mhm.
not just are you eating right, are you working out, are you sleeping, but also is your environment conducive to what you're trying to achieve occupationally? Do you feel like you're in a good space with wellness as well? So
Yeah.
also looking forward to that article. And I'll move on to our final question before I open the floor up for Q&A. And that is, are there any recent legal changes or trends in wellness programming that attendees should be aware of?
Huh. Well, I think there is an awakening to these broader issues. I don't think it's really filtered down into the actual workplace. Well, most workplace wellness programs that I see still are very traditional with, the HRA and the biometric screen is like the gateway to other, coaching and more, again, individual personal responsibility, lifestyle choice activities. But I think there's a slow recognition that there needs to be a broader view of what constitutes well-being, and beyond an individual's behaviors. So that I think is good because, and I think what's in part prompting that are some of the lawsuits that have occurred and are still occurring, where employees feel like all the employer really cares about with this wellness program is my data. They just want me to fill out these forms or take this blood test so they can get my data, my personal health information, and charge me more money because I don't meet whatever criteria they've set. And so their employees, have filed quite a few lawsuits based on that premise and using the Americans with Disabilities Act as the primary legal vehicle for doing it. And so I think because of these lawsuits, employers are taking a little bit of a step back and saying, well, what is the purpose of the better employers, the employers that really care about their employees, are taking a step back and saying, well, what is this really all about? Why are we having these wellness programs? And so to in part avoid the accusations and the lawsuits of just trying to collect data and when you tie incentives to data collection like HRAs and biometric screens, that's when employees feel like they're being coerced. They're not choosing to give the employer their data. They're being forced, because if they don't, then they have to pay more for health insurance, or they have to get money taken out of their paycheck. And so I think that there is this recognition that it's probably not the best idea from a legal standpoint.
Yeah, and I love how you started to mention about like the better employers who are taking that step back to think about, what are we doing this wellness program for overall? And my next question was going to be, what's some things that employers can start to do in order to make sure they are encompassing that whole person approach? And I think you kind of hit the nail on the head with that. It's like going back to the drawing board and saying, like, what is our goal of creating this program? Is it just to say, hey, we have one and check off a box, or is it to truly improve the well-being of our employees? And if that's what it is, what does that fully look like?
Yeah. And I have ideas about that too. That's also in my article. I call them wellness legal partnerships, wellness legal partnerships that can be run through an employer's EAP, or can be a partnership with a wellness vendor, or it could be a business coalition that adopts a wellness legal partnership. But what it does is looks at the social determinants of well-being and offers a resource for employees who may have some environmental, socioeconomic challenges that are preventing them from living their best life. And so offering that legal/social work kind of resource to employees through the wellness program, and as a way to kind of get at that broader picture of what well-being looks like.
Oh, that's awesome. Oh, like I said, cannot wait to read this article. Okay, so now I will open up the floor for audience Q&A. So to our participants, if you all have any questions for Barbara, please feel free to put them in the chat, or feel free to raise your hand and we'll make sure we get you off mute to ask your question out loud.
Hi, it's Dave Power.
Hi.
So could you talk a little bit more about the business coalition that you were mentioning?
Oh, well, I mean, I didn't have one, there's
No, no.
all kinds of business coalitions out there. I didn't have one in particular in mind. I was just saying as another opportunity for a wellness legal partnership, a business coalition that might exist in a community, in a state. I don't know about nationally, but I guess. I know there's a national business group on health. There's, in Wisconsin, my home state, my former home state, there was a group called the Alliance, which is a bunch of self-funded employers who are, pay membership fees to get better deals on group health coverage. And there's another group called Self-Fund Health, a similar kind of deal with the direct primary care model. Or, in Kansas, where I live now, there's a business coalition of mostly self-funded employers who, are associated so that they can learn from each other. And so if you tap into one of those business coalitions and offer a wellness legal partnership to the members, the employer members, who might be smaller employers and not able to really fund one of these on their own, but if they were part of a group of employers, then it might be more feasible financially to fund one of these legal partnerships.
Like, how would that wellness legal partnership look in general?
Well, it would be probably funded through association fees. However, the employers who belong to that coalition are paying for their membership to belong to that coalition. It could be built into that membership fee, and then the legal partner would be a resource that employees of those employers could use as issues come up, and it would be offered as part of a wellness kind of program. So that was one idea that I had. It's not the only way you could fund it. You could partner with the actual wellness vendor who's coming on site to do the wellness programming. And yeah.
Okay, great. Thanks, Barbara. Always good stuff.
Thank you.
Do we have any other questions from our audience? All right. Well, Barbara, I would love to thank you for your time.
Yes, you're welcome.
And thank you all for joining us today. So if you all are interested to learn more about Wellness 360, our solution to improve employees' health and well-being, please visit our website. Once again, I'm Zikea McCurdie, the Wellness Manager at Wellness 360, joined by Barbara. And thank you all for joining us again. Thank you for sharing your wisdom, Barbara. We would love to have you back, further discuss some of the topics we started touching on today.
Absolutely. Thank you.
Of course. Have a great day.
All right. Bye.